They are the smart guys. They often appear together out on the judicial circuit, which I think is probably dashed. Erwin, before we go to a roundup of the Supreme Court this year, what are we doing about bar review courses this summer? Is it all, you're like the grand master of bar review courses. Are they all being remotely done?
They're all being remotely done. And of course, part of the problem is California still hasn't announced yet when or how the bar exam is going to be administered. So it's causing great anxiety for the students here who are studying for the bar.
Oh, wow. All right, let's get to the Supreme Court just concluded term. John Eastman, you get the first shot at summarizing the year that was in the Roberts Court.
Well, of course, John Roberts is being touted, I see in some circles, as the greatest Chief Justice since John Marshall. I think that's vastly overplayed. I think there are a number of cases. I think there are a number of cases that are just quite frankly perplexing. The Chief's ruling in the DACA case, for example, Neil Gorsuch's textualist ruling. He calls, I put scare quotes around that, in the transgender cases, the Title VII cases, and in the Oklahoma Indian reservation case, which puts about half of Oklahoma into an Indian reservation that we haven't thought was there for over a century. So there's some very odd cases. There are some good religious liberty cases, but also some red flags to caution religious liberty advocates for in the future, including the Little Sisters of the Poor case, which is decided on deference administrative state grounds rather than religious liberty grounds. And that poses a problem the next time the White House changes hands, I suspect. So it remains to be seen what the ultimate impact of this term is, but it's certainly a mixed bag.
Erwin Chemerinsky, your turn at bat.
It's truly the John Roberts court. John Roberts was in the majority in 97% of all the decisions. He dissented only twice all year. And as you know, when he's in the majority, he gets to assign who writes the opinion. And he wrote the opinion in so many of the most important cases of the year, the presidential subpoena cases, the religion cases, the DACA case. We knew when Anthony Kennedy retired that John Roberts was going to become the swing justice on the court, but we sure saw it this term.
Now, we've had a couple of years to study Justice Gorsuch. We've had a year to study Justice Kavanaugh. How have they changed the court? What did their jurisprudence say to you, John Eastman?
Well, I think, both of them have fairly consistently, with some notable exceptions, been on the right side of center of the court. I agree with Erwin. John Roberts is more frequently the swing justice than either of them. But I think Justice Gorsuch's opinion in the Oklahoma case and in the Bostic case, the Title VII transgender and sexual orientation cases, indicates he's more of an heir apparent to Anthony Kennedy than people had expected.
Erwin.
I don't agree at all. I think Neil Gorsuch is much more conservative than Anthony Kennedy. I think Brett Kavanaugh is much more conservative than Anthony Kennedy. For Neil Gorsuch, he's a serious textualist, and sometimes that will take in a surprising direction, like the Title VII case about gay, lesbian, transgender individuals being protected by Title VII. I think he's a strong protector of Native American rights, and that's what explains the Indian law case. For Brett Kavanaugh, there wasn't a single instance this term where he wasn't with the conservative justices. Maybe you could say the subpoena cases, but even then, though he concurred in the judgment, he was much more conservative than Chief Justice Roberts' majority opinion. So I think that conservatives should be thrilled by Brett Kavanaugh and overall thrilled by Neil Gorsuch as well.
I also want to talk now specifically about Our Lady of Guadalupe, which I know some people think Espinoza versus Montana is more important for religious liberty, but I actually believe Our Lady of Guadalupe is. John Eastman, what was decided there? How significant the case?
Well, it's very significant. A few years ago, the court recognized a ministerial exception for teachers that have the title minister, teachers that convey church doctrine in the church schools. Now, not all religious sects so freely use the term minister as the sect that was at issue in that case. And so the issue here was, even without the title minister, as somebody that is performing religious duties and conveying religious doctrine in some fashion in the schools, also entitled to a ministerial exception. or to put it differently, does the church have to be compelled by government on who to hire to conduct that part of their religious exercise? And the court held that we look to the function of the position, not the title given to it. And churches have to be free to make their own choices about who's conveying their religious doctrine. If government, through anti-discrimination laws and otherwise, is able to make those choices for the church, that's a huge intrusion on the exercise of religion by the religious institution.
Now, Erwin, if I can summarize for you the conservative reaction to this term on religious liberty, it's split. The David French camp says religious evangelicals and Catholics and other peoples of faith have never been so protected in their free exercise rights. People like Ryan Anderson, I suspect John, say, but it's all precarious. It's 5-4. What is it from your perspective on the left side of the spectrum? A glass half full or a glass half empty for people of faith?
Oh, I think the glass is far less than half full. I think this was a terrible decision. It means that any religious school can discriminate with impunity based on race, sex, religion, sexual orientation, age, disability, even if there's no relation to the tenets of the faith. These two cases that were combined involve teachers who were fired for age and disability. I don't believe that religion should be able to inflict injury on others. In the words of constitutional law, I think there's a compelling government interest in stopping discrimination. Also, 30 years ago, Justice Scalia wrote the opinions of the court in Employment Division versus Smith and said, religions don't get exceptions from general laws. But that's exactly what the Supreme Court did here.
And John Eastman, I want you to respond to that because I think he just took a position that both David French and Ryan Anderson would disagree with. At least we've got to save the ability of churches and faiths to function as they want to function, and that's Muslim, that's Jewish, that's Christian, it's whatever Baha'i, whatever you want. They've got to be left alone.
Well, that's right. And before Justice Scalia's opinion 30 years ago now in Employment Division versus Smith, the Constitution itself protected that. We're now dealing with federal statutes that have provided this exception, to use Erwin's language, which I'll disagree with in a moment, exception to religious faith. What we're talking about here is who gets to decide who's going to convey our religious doctrine. Does the church get to decide that, or does some federal statute enacted by Congress get to decide that? The exception crafted for religious exercise is actually one that, as originally understood, the First Amendment itself provided, because of the primacy of religious faith and the obligations one owes to a higher authority than any government. That's the basis, the central theme, the central purpose of the First Amendment. So what I'd really like to see, and I think it's certainly up for revisiting, is Employment Division versus Smith overturned. These cases are a minor step in that direction, but only a minor step. We're still relying on statutory authority that can be changed in a heartbeat.
From your lips. Okay, Erwin, I want to go to the presidential subpoenas. These I have described in the Washington Post as elegant decisions. They have balanced the two branches, I think, just perfectly. It's why my esteem for Roberts has gone up. Your assessment of them?
Well, you got to take them separately. I think Trump versus Vance was exactly right. There, the court said that the president has no immunity from grand jury subpoenas. John Roberts, writing for the court, said the law has the right to every person's evidence. The president can raise the same defenses to a subpoena that anybody else can. The other case, Trump versus Mazars, I'm more critical of. The D.C. Circuit basically said Congress has the ability to investigate, and just because it's financial information concerning the president, there's no exception. John Roberts, though, said there has to be a balancing test, and Congress has to meet need for showing heightened need, and there's no other source of information in order to get financial information concerning the president. And I think this gives too much protection for the president.
John Eastman.
Well, I want to take issue with Erwin's description of Trump versus Vance, the New York grand jury case. What the court held was that the president didn't have absolute immunity from the issuance of grand jury subpoenas, and it also denied or rejected the government's request to give heightened protection to the president, and that he had the same kind of objections to subpoenas that anybody else had. But then it went on to say But this is the office of the President of the United States. If there's any hint that these subpoenas are being used for political purposes, to interfere with the office of the President of the United States, then the Supremacy Clause would step in and block that. So there is still a set of arguments that can be made and undoubtedly will be made by the President's lawyers to forestall these subpoenas, which have every appearance of a witch hunt because of political opposition to this president rather than the kind of thing we would normally expect. As for the House of Representatives subpoenas, the House doesn't get to go after private individuals as if they're the law enforcement branch of the government. That's Article 2. That's the president who is in charge of law enforcement. Congress can get all sorts of information necessary for legislating, but the notion that we can target one guy that we don't like politically because generically we find that we might gain some information that might help us legislate is such a pretextual claim for that witch hunt that I think the court rightly struck that down.
All right, last word goes to you today, Erwin, on McGirt, because the Native American legal community is celebrating. Justice Gorsuch did side with the liberals here in its discussion, but does it have actual practical consequences in Oklahoma beyond that which occurs on tribal lands that remain tribal land?
Well, that is the practical consequence. It means that if there's a tribal member who commits a crime on the tribal land, that person has to be prosecuted in federal rather than state court. Keep in mind that this is because of the court's interpretation of a federal statute. Congress can change this if it wants. I think the interesting question, and I've yet to see a clear analysis of it, is how much other tribal land is in the country where there are similar treaties where there might be the similar effect.
And John, very quickly, do you know, we've got 30 seconds, have you done that study yet? Because I just don't think this is the big deal that a lot of people think it is.
Well, I think it's a big deal as far as Oklahoma is concerned. And, you know, at some point after 100 years, there have been a number of statutes subsequent to the one that was interpreted in this case that strongly indicated that the decision here was wrong. I think that people living in Tulsa, to find out they're now living in Indian territory and not subjected to state law or the protection of state law is rather dramatic. And that's the effect of this decision.
Erwin, do you agree with that? Really, 10 seconds. Do you agree with I don't think it is.
No, I don't think so at all. I think that in practical effect, it's much more limited than that. And I also encourage people to read the last paragraph of Justice Gorsuch's opinion, which is a very powerful one about how promises made to tribes need to be kept.
Erwin Chemerinsky, Dean of the Berkeley School of Law, John Eastman, Dean Emeritus of the Fowler School of Law at Chapman University. Thanks to you both. The smart guys are always terrific at the end of the term.